some of the very interesting and unique facts about one of the greatest and most landmark judgment of the Supreme Court of India in the matter of Kesavananda Bharti versus State of Kerala. The core question, apart from the validity of 24th, 25th, 26th and 29th constitutional amendment, was whether the Parliament has unlimited power to amend the Constitution or whether there are any implied restrictions on amending the Constitution. The 24th Amendment to the Constitution invalidated the landmark judgment of the Supreme Court given by a bench of 11 judges in the matter of I.C. Golaknath. The 25th Constitutional Amendment invalidated the landmark judgment of the Supreme Court in the matter of R.C. Cooper, also known as the bank nationalization case. The 26th Constitutional Amendment invalidated the landmark 11-judge bench decision of the Supreme Court. Privy Purse. The 29th Constitutional Amendment placed the Kerala Land Reforms Act of 1963 under the 9th schedule and therefore saving the said act despite the provisions of the said act being ultra-virus to the Constitution and having declared some of the provisions as being ultra-virus by the Supreme Court of India. Therefore, Kesavananda Bharti challenged the provisions of the Kerala Land Reform Act along with the constitutional amendment before the Honorable Supreme Court, wherein a 13-judge bench was constituted to decide one of the most important questions on constitutional law. There are several interesting, unique and unknown facts about this case. The judgment was delivered on 24th of April 1973 on the day of retirement of Chief Justice of India, Justice S. M. Sikri. It is the only case to be decided by the 13 judges of the Supreme Court of India. It is one of the largest bench who heard the longest hearing, which spanned for 68 days over 5 months, covering the widest areas of law and legal literature, resulting into a 703-page judgment with 11 scholarly opinions. The Supreme Court, by a razor-thin majority of 7:6, for the first time in any constitutional adjudication in the world, propounded the doctrine of basic structure, where the power of the Parliament to amend the Constitution was held to be not unlimited, and the Supreme Court held that the Parliament cannot amend the basic structure of the Constitution. Interestingly, there was no unanimity on what constituted the basic structure of the Constitution despite 11 opinions and despite the majority of 7 judges, who did hold that the power of the Parliament